Hi, dear. So, if you are watching this video, definitely you want to get an answer over a question that what exactly is the criteria for determining patent infringement in India? The other way to ask the same question is a situation, maybe a person A, which is you. You are doing a business in India, you have a patented invention, your business is at boom, and now what you see is there is a person B and he's using same or substantially similar product or a process, and he's taking away your benefits, taking away your profits, because he's also doing the same, using the same product which is yours. It's your patent, by the way, and no one else is allowed to make, use, import or sell that product without your permission. So you think that person is infringing your product, your patented invention, and now you want to know that what exactly is the criteria for determining patent infringement in India, so that you have well information in advance, and when you go in front of legal authorities and take a legal action, you're well aware what you are doing. So this is the situation. So let's get answer over this question. See, there are two things you should research on. One thing is that your patent, which is patented invention of yours, it should be valid. It should be really something which no one has done before you. It is valid and it is enforceable actually. And if you are sure of that, then what you have to test is that the features of the product or the process of that person B, which you see as infringing your patented invention A, the features of that product or process should fall within the scope of the claims of your valid patent. So what you have to analyze, you have to match up the claims of your patented invention with the features of that product and process and see if exactly it is a match or some features are being infringed and not other claims. Some claims are being infringed and not exactly all the claims. It's not exactly similar but substantially similar. You have to analyze this. Then you have to be very sure that that person B is making or selling or importing the invention, the product, that product which is infringing yours without your permission. That person has not taken permission from you, and he's doing that work without your permission. So if you're sure of that, then definitely that product is infringing your patented invention. One more thing I would like to mention over here is that these concepts of infringement and patent are territorial in nature. You cannot say that a person is in, you have an invention in India, and you cannot say that a person in Japan is using same invention as yours, he is selling same invention as yours, when you don't have a patent in Japan. So that person is doing that work in Japan. You cannot take a legal action against him, as the realm of the legal action is within India only. So the rights are within India only. If you want to do commercialization your business in Japan, you have to take a patent in Japan as well. Then you can say that person is Japan is infringing your product or a process when you have a patent in Japan as well. So these are territorial concepts. So if I just summarizingly give you a definition, or not definition, but tell you the answer on what exactly is the criteria for determining patent infringement in India, then I must say that infringement of a patent occurs when someone within your jurisdiction, where the patent is granted actually, engages in activities, any activity, making, using, importing, selling, offering for sale, engages in activities that fall within the scope of your patented claims, and he does this without the authorization, without your permission, without your consent, and then the patent holder can really take action within that country only to enforce his or her rights and seek remedies for infringement. You can definitely get remedies. Now, this is a new topic about remedies. So, what justice is provided on infringement? It depends upon multiple factors. What are the remedies provided? It depends upon multiple factors, like what is the accused product or process. Means, is it what type of accused product or process? Is it a patented product or a process, or is it something which is not patented? It may be patented or may not be patented. Maybe someone has not a patent over it and he's just using that invention. Maybe he or she has a patent over it, which IPO has granted after the filing date of yours, after you have filed the patent application. What I mean is, maybe you had filed a patent application on an X date. Now, this person filed the patent application for the substantially same invention or exactly same invention on another date, which is later than your date. But then, Indian Patent Office didn't realize, based on the prior arts available or published, and by mistake they have given a patent to that person. So it may be a patented one also, which infringes yours, but it may be something which is not patented, that person is using before or after the date when you filed the patent at Indian Patent Office, and but he's not having a patent over it, so definitely he's not allowed to use that invention without your consent. So these are the two different kind of scenarios. Plus, something which is tested by the jurisdiction, the legal authorities, is that, is it exactly the same invention as yours? Exactly all the features are exactly same, they match with your claims, or substantially same, or maybe some claims of your patented invention are infringed and some are not. What exactly is the situation? Depends upon case to case. Maybe some portions are infringed and some portions are not infringed. So that decides, will you be getting damages and accounts of profits, or it's just a simple injunction which will take place, or some kind of collaboration may take place between the two parties. It depends upon case to case. And one thing which is also analyzed is, that is the invention which is in the person who is infringing your invention, has that person infringed your invention intentionally or unintentionally? Maybe he's not aware that you are having a patent over it, maybe, but maybe he knows and he is still doing this. So this is something which is intentional and decides the relief you will be granted. So, coming on to the reliefs, uh, uh, reliefs may be injunction, that that person is asked to stop all the work he's doing. You have to stop whatever product or process you are selling because you are infringing. So, complete stop over whatever that person is doing as a business, because he is infringing your product. Secondly, you may be given the damages or accounts of profits, whatever loss you have had because of the use of that your invention by that infringer. So you may have those damages also, depends upon the case. And the court may ask the destruction or seizure without any compensation to that person who was infringing your product or process. This may also be the case. But okay, we have understood what exactly is the criteria of determining infringement in India. But in India, there are a few activities which are not considered as infringement. We should know them, because if we know them in advance, we don't make a bad decision, we don't spoil our money where it was very obvious that this is not the case, but then still. So we should be aware of some activities which are considered as non-infringing activities. So number one is making and importing of a product or a use of a process by government for its own purposes. If government uses a product for its own purposes, it is non-infringing activity. Plus, if someone uses your product, patented product or a process, for the purpose of research, maybe teaching or education or experimental purposes. For these purposes, if someone is using your product, it is non-infringing. Also, if you have a patent over a drug, or a pharma side, you have patent on a composition or formulation, something like that, and then it is used by the government for maybe its own use or for distribution in some hospitals, dispensaries, or medical institutions, that is also not considered as infringement. There are a few more specific scenarios which are very critical to specific types of cases, like maybe some vehicle coming into your area and accidentally. So this doesn't come as of now. There is no need to discuss them, but there are very different types of cases which define that this action is infringing, this activity is infringing or not, and we should be knowing about that. Thank you so much. I hope you like the video and now you're more aware that about the criteria of infringement in India. If you are having any more different types of questions which come up in your mind as an inventor and you would want to get an answer over, then definitely write a comment and let me know. I'll upload a new video on those questions. I will try to answer all those questions in different videos. And yeah, thank you so much. Please subscribe. Thank you.